President.
Almighty God, we humbly beseech Thee to vouchsafe Thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of Thy glory and the true welfare of the people of our state and Australia. Our Father, who art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us, and lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power and the glory, forever and ever. Amen. I acknowledge the Gadigal clan of the Eora Nation and its elders and thank them for their custodianship of this land. Honourable members, I wish to advise members of the arrangements in place for COVID-safe sittings of the House this week. Members would be aware of the COVID-safe plan to support the sittings of the Legislative Council in September. I now table the most recent version of the plan, circulated on the 9th of September 2021. The plan proposes familiar COVID-safe practices such as social distancing, QR code check-ins and regular hand sanitising. However, the plan also suggests additional provisions to minimise risk to members and staff during the current sittings. This includes compulsory mask wearing, rapid antigen testing, a strong preference for staff and members to be fully vaccinated, and reduced sitting hours, including a break in proceedings approximately every 2 hours to allow the chamber to be cleaned. A key element of the plan is for a minimum number of members to be physically present in the chamber, with other members participating remotely. A draft temporary order authorising remote participation was circulated last week. Until this order is agreed by the House, the members who have joined the WebEx call this afternoon on the screens behind us may listen to and observe the proceedings, but may not participate at this time. With that in mind, could I request all members who have joined the WebEx call to remain on mute at this stage? I also remind members to select the chamber view Move to Stage in your WebEx settings. I take this opportunity to acknowledge the extraordinary efforts of officers in the Departments of Parliamentary Services and the Legislative Council, particularly the leadership of the Chief Executive Officer Mark Webb and our clerk, the Honourable Mr David Blunt, to develop the infrastructure and procedures to allow for these remote sittings. The Honourable Trevor Khan.
Mr President, can I draw to your attention the state of the House, and more particularly the absence of a Minister or Parliamentary Secretary in the House? And in that respect, Mr President...
Order.
Not telling you about his promotion.
Order.
And in that respect, Mr President, can I bring to your attention Standing Order 34? Now, Mr President...
Order.
Now, Mr President, you'd be aware that Standing Order 34 provides that the House will not meet unless a minister is present in the House. This is a standing order that has been present in the rules since the new rules in 2004 came into place. I tell you, Mr President, that the annotated version of the standing orders in the name of Want and More deal with the issue on page 100, and more particularly in that regard, states where a minister or a parliamentary secretary acting on their behalf is not present when the House meets, or a member calls attention to the absence of a minister during a sitting, the President must leave the chair until a later hour. Now, Mr President, can I note that this is not an academic matter. It is a matter that has arisen on 3 occasions since the standing orders came into force. Indeed, before the standing orders came into force, there have been numerous instances of the convention of the House immediately rising in the absence of a minister occurring. My recollection is in the 80s, there were 3 occasions on which President Johnson left the chair when a minister was absent. In 2001, I believe it was, Deputy President Kelly left the chair when a minister was absent. After 2004, there have been 3 instances. An unusual instance in 2004 when Deputy President Fazio was in the chair, when her attention was called to the absence of a minister by the Honourable Patricia Forsyth. She took the unusual and indeed inappropriate step of causing the bells to be rung, but nevertheless recognised that the standing orders required the presence of a minister. We then have, in 2005, President Bergman leaving the chair. That's in Hansard on the 21st of June 2005. And the latest occasion was on the 24th of June 2009 when President Primrose left the chair immediately. The minister was absent. Now, can I note that in regards to the instances of President Bergman in 2005 and the instance of President Primrose in 2005, those 2 occasions arose in circumstances where Hansard does not record a member drawing the President's attention to the absence of a minister. In both cases, the President acted, in my view, quite properly by immediately leaving the chair upon that circumstance arising. Now, can I say that what we've got particularly in the last instance, in 2009, is a number of members still in this chamber who were members of that chamber in 2009. You being one of them, me being another, the Leader of the Opposition being another, and of course there are others who are not formally participating today who also are in that circumstance. Of course, Reverend Nile also fitted in that category. So the position, I suggest, is quite clear. Standing Order 34 requires that you leave the chair now. Standing Order 34 requires this House to go out on a long bell. There is no equivocation. I suggest, with respect, Mr. President, there is no issue for debate. The sittings of this House should end immediately.
On the point of order?
It's not a point of order.
On the point of order that's been taken?
Honourable members, the Honourable Trevor Khan has moved a point of order, drawing attention to the absence of any minister or parliamentary secretary from the House today, and has made extensive submissions in relation to that point of order. Let me remind members that Standing Order 34 stipulates that the House will not meet unless a minister is present in the House. Standing Order 34 was included in the standing orders in 2004, and according to, as the Deputy President referred, the annotated standing orders is the formal expression of a long-standing convention that a member of the Executive is present both to ensure the smooth progress of the government's agenda and also to answer questions and provide clarifications on matters in a House of review. There is a precedent for use in this manner by the then government in 2009, as referred to by the Deputy President, to effectively terminate a sitting of the Legislative Council. On that occasion, the House was taken completely by surprise, and the President immediately left the chair on ministers and parliamentary secretaries having left the chamber. On this occasion, in contrast, the government's intention to not have a minister or parliamentary secretary present and thereby to prevent the House from sitting has been communicated in advance in correspondence from the Leader of the House. Honourable members, this is an extremely grave matter, and I'm aware that a number of members wish to address me on this foreshadowed point of order. If, as may ultimately be required, I am left with no choice but to vacate the chair and bring the sitting to a close. The least I believe I can do as your President is to first hear members' contributions on the point of order. I will therefore allow debate on the point of order, but I do remind members that debate is required to be relevant to the point of order. I also draw members' attention to Standing Order 95 subsection 6, which allows debate on points of order at the discretion of the Chair or the President. I also draw members' attention to selected President rulings, and indeed the ruling of former President Jarka on the 20th September 2017, where it states the President is under no obligation to rule on matters immediately. It is appropriate that careful consideration be given to certain matters, particularly when a matter arises for the first time in the term of a President, and indeed I would add, in a grave matter which strikes at the heart of the House of Review sitting. With those few words, I am willing to entertain debate. The Leader of the Opposition.
Thank you, Mr. President. Democracy is an essential service for the people of New South Wales. As we stand here today, our state continues to face one of the most significant health crises we have faced in recent history. This crisis is a result of the COVID-19 virus that has turned into a worldwide pandemic. In New South Wales, 242 people have lost their lives. Since January last year, 45,593 people have contracted COVID-19. There are 1,127 people who found out in the last 24 hours that they are COVID positive. 1,253 people are fighting for their lives in our overworked hospitals. As we pass the 12-week mark of lockdown, cases are set to peak and there is immense pressure on hospitals. Now more than ever, the community needs answers from government about the way ahead. What New South Wales needs right now is hope and transparency and accountability from their government. It is shameful that the Berejiklian government could come into this chamber and misuse the rules of the House to stop the majority of elected members from sitting lawfully. With 8 million people in lockdown, over 2 million people living under curfews, businesses falling over, an emergency mental health crisis. Are you really going to do that?
The Honourable Trevor Khan on a point of order.
President.
I understand the introductory remarks that the Leader of the Opposition is making. But this is an argument over the standing orders. It's actually not a generalised debate. And I'd ask you to bring her back to the issue, and that is, it would seem, whether Standing Order 34 applies.
Look, I think the member was making some introductory comments, and I think she was about to come to the substance of the debate, which is indeed Standing Order 34 and its application in these circumstances as to whether the House should continue to sit or should adjourn immediately. And in that regard, reasons in relation to why the member believes the House should remain sitting are relevant.
There's an emerging mental health crisis and parents are desperate to get their kids back to school. The time for scrutiny and accountability has never been important. Every day, people are calling up their local members of parliament for help. Our local members are working as food packers, translators, vaccine centre coordinators, community information hubs and assisting thousands of people every day. This is important work, but it is not their primary job. Our elected representatives are the voice for our communities. We are entrusted to ask the questions, seek the answers and get help on behalf of the people we represent. It is our job on behalf of the people of New South Wales to hold the government of the day to account, to provide scrutiny of their decisions. If we are prevented from doing this, we are no longer living in a democracy. The fragile social contract that exists between those that govern and those that are governed must not be taken for granted. Mr. President, a positive COVID test has serious consequences, not just for your health, but for the lives of your family and your household. It has serious consequences for your business and your ability to put food on the table and a roof over your head. Since the beginning of this pandemic, the people of New South Wales have been asked to do so many things that prior to last year we had never contemplated. Social distancing, mandatory masks, border closures, lockdowns, curfews, and the race for a vaccination are part of our daily lives. We've had to close all but the most essential of services and businesses. We've had to work from home where we can. Our children have stopped attending school, stopped playing sport, stopped being able to see their friends. We have missed birthdays, weddings and funerals. We have not been able to be with loved ones when they are sick or when they are lonely. For those doing it tough in insecure work, in tenuous housing or in overcrowded houses, those relying on support workers, those lacking good Wi-Fi or the ability to connect to and navigate the internet, life has been even tougher. Under these circumstances, we have learned what it really is to be essential. It's our health workers, our truckies, our retail staff, our logistics and distribution workers, cleaners, garbos, teachers, early childhood educators, police, fireys and ambos, community workers, bus and train drivers, and our scientists. Heroes wear many capes, and I take this opportunity to thank them for everything they have done and are continuing to do. Our community has been prepared to do what is necessary to keep our families and our communities safe. Adherence to extremely tough public health orders that our community is living with requires that the government who has imposed these orders is accountable for them through the Parliament. This House has not sat for 82 days. The government has arrogantly come into the chamber today and said that they will not allow us to sit for at least another 28 days. No other parliament in Australia has taken this drastic action. Every other parliament, no matter which political party is in control, has respected the basic democratic rights of its people and have found a way to keep functioning. In New South Wales, we have a government that has cancelled Parliament and now cancelled the daily 45-minute media conference to provide information and advice to the public. The Premier and her cabal of ministers in the crisis cabinet seem to think that scrutiny of their decisions is optional. We are gathered here in the chamber today to say to the Premier and her ministers that scrutiny cannot and must never be optional. The only conclusion that can be drawn from the actions of the government today is that they will do anything and everything to avoid the Parliament sitting and holding them to account. There is no health advice that says we should not sit. As I stand here in the knowledge that I am in a workplace with one of the most stringent COVID safety plans in New South Wales. I have had a rapid antigen test. I am double vaccinated, and I have been sitting alone in my office without staff and coordinating the opposition remotely. Through technology and an enormous amount of work by the staff of the Parliament, we have 33 members of the Legislative Council ready and able to get back to work. The actions today by the Berejiklian government are an insult to the Parliament, but more importantly, their actions are an insult to the people of New South Wales. The government should front up right now and let us get on with the job our community elected us to do.
The Honourable Mark Latham.
Thank you, Mr President. I come to the point of order by bringing to your attention Standing Order 4, Rights of the House Not Restricted. This standing order reads as follows: nothing in these standing orders affects the rights, privileges and powers of the House. And properly understood, this overrides and negates the intent of Standing Order 34, as imposed by a representative of the Executive, to try and abort the democratic sitting of this House, to wipe our privileges, to wipe our rights, to wipe our powers, to represent the people of New South Wales. And the honourable member, acting on behalf of the Executive, who raised this matter, quoted from Want and More. I do as well, with regard to the operation of Standing Order 4. It's written in the commentary on our standing orders as follows, and I quote, Standing Order 4 reflects the principle that the standing orders regulate the manner in which the House performs its functions and the practical operation of the rights, powers and immunities inherently held by the House, including the orderly conduct of business. So there's no doubt that the standing orders reflect the manner in which we perform our duties, but under Standing Order 4, those duties, those powers, those privileges cannot be withdrawn. And Standing Order 4 clearly states, Mr President, that it overrides any attempt elsewhere in the standing orders to take away the privileges of this House. And as you indicated earlier, sir, there's nothing more important to a parliament, nothing more important to parliamentary democracy than the notion of privilege. Privilege gives us the right to be here, to represent the people of New South Wales, to exist in a democracy. It gives us our freedom of speech, our right to call witnesses at committee meetings, to have committee meetings. Privilege is all important and an essential foundation stone by which this parliament operates. And clearly, under the provisions of Standing Order 4, it protects privilege against all other provisions in the standing orders, particularly one like 34, which I submit is being misused in this circumstance. As the Leader of the Opposition pointed out, there is no health advice saying we cannot sit. There is no evidence that ministers have been drawn away on urgent business of the state and can't be present. In fact, we know the health circumstances are okay because the government has sent Trevor Khan in to raise this point. There's a government advisor sitting in the box. The health advice does not say we cannot sit. There is no evidence that ministers have been drawn away urgently. The evidence points to the fact in the preemptive Damien Tudhope letter that you mentioned earlier on, that this is a deliberate strategy of the government for one purpose and one purpose alone, to avoid accountability, to avoid transparency, to avoid debate about all the matters that have been raised, grave matters of state raised by the Leader of the Opposition about the economic, social and community health of New South Wales, with people, I believe many hundreds of thousands of them, screaming out for parliamentary debate, screaming out for representation, screaming out for democracy. And then I come further in wanton more, Mr President, to point out that Standing Order 4 was first adopted in 2004. The terms of it are similar to Senate Standing Order 208, which states, and I quote, "Except so far as is expressly provided, these standing orders do not restrict the mode in which the Senate may exercise and uphold its powers, privileges and immunities." So again, nothing else in the standing orders, including 34, can limit or restrict the powers, privileges and immunities of this chamber to exist. Wanton more make other telling points and conclude by saying it is likely that Standing Order 4 was adopted as a safeguard, note that word safeguard, against a hostile majority amending or adopting a standing order that could take away the rights of the minority and, most importantly, or inhibit the accountability of government. So Standing Order 4 is deliberately in the standing orders of this place to protect our privileges, our powers, our immunities, and to ensure that the executive government, under the separation of powers, cannot inhibit the accountability of that government. So there's no doubt in any correct reading of these standing orders, Mr President, that Standing Order 4 is our safeguard against the tyranny of a government that doesn't want to face accountability. The tyranny of a government that preemptively, arrogantly sends you a letter to say, oh, we're just not turning up. We're not turning up. We've got no valid reason. We're not turning up because we don't want to face debate. We don't want to face transparency. We don't want to be part of a representative process for the people of New South Wales. So Standing Order 4 clearly overrides, overrules and negates Standing Order 34, which is being misused. If you look at the history of this chamber, Standing Order 34 was always designed as a help to this chamber, not a hindrance. It was designed to help the chamber by having a representative of government who could be held to account. And back in the days before representative democracy, before we had elections, back in the days where members were appointed, it was quite common here, Mr President, for just one representative of government to be available in the LC, invariably the Vice President of the Executive Council, and I'm sure in those more relaxed and comfortable days, if I can put it that way, that every now and then the one minister would have thought, not much happening here, I might go have a drink with the boys or dinner in the dining room, and they'd wander off and the House was disrespected. The standing order was only ever there, only ever put in place as a courtesy, as a mark of respect to this chamber, to make sure there was a minister present, not for the purpose of aborting the sittings, not for the purpose of cancelling democracy, not for the purpose of a Leader of the House shamefully sending you a letter days in advance to say we're not participating. It was never designed for that. And clearly it is overruled by Standing Order 4, our great protector of privilege and the right of this chamber to exist and debate. And I note your letter, Mr President, of the 5th of September to Minister Tudhope, and I quote at length because they were very telling comments that I support and I believe should further guide you in your judgment and your ruling today. It appears your advice, the Tudhope advice, overlooks the fact that the normal operations of Parliament are an exempt gathering under Schedule 2 of the Public Health Order concerning public gatherings, and members of Parliament and parliamentary staff are authorised workers under the terms of the Public Health Order. This means that the current public health orders contemplate Parliament sitting during the pandemic and enable members and parliamentary staff to travel to Parliament for this purpose. And then you conclude, finally, as you, Hope, appreciate, it is the duty of the President to reflect the will of the House. Hear, hear. I am sure you will agree that in making decisions regarding future sittings of the House, it is important that we all reflect upon the critical role of the Legislative Council as a House of review, charged with the duty to hold the executive of the day to account as part of our democratic system of responsible government. I submit to you, sir, having noted the contents of that letter, having noted Standing Order 4, having noted the contents of Want and More, I submit to you, sir, that we do have an obligation and indeed a legal basis here for the sitting of the chamber using Standing Order 4 to override the misuse of Standing Order 34 for this explicit purpose of preventing a government avoiding accountability in the chamber. We must always, as a chamber, uphold the privileges and powers and immunities of this House. And I've got to say, I find it disgusting that a presiding officer of this chamber would come in as a hand puppet of the government to try and close down this chamber. I find it disgusting.
Order. The member is out of order. I draw the attention of the member. The President is sitting. Resume your seat. The member is being disorderly. I call the member to order the first time. This is not the time for this. If you wish to take any objection to any conduct of any member in this place, you know the rules. You do it by substantive motion. You have the call.
Thank you, Mr. President. I look forward to that opportunity, and I note the setting in which we find ourselves in these extraordinary circumstances. I submit to you we have every right to sit. We must sit. Legally, we should sit.
Mr. David Shoebridge.
Mr. President, I rise on behalf of the Greens to indicate our utter contempt for the government's actions today. And I do that noting my two colleagues, Ms Abigail Boyd and Ms Kate Fairman, are joining us by video conference, ready to participate in a COVID-safe hearing of Parliament. And indeed, while we're here having this debate about whether or not Parliament can sit, the government is refusing to provide a minister, allegedly because of public health reasons. But let's be clear about this. They are using COVID as a charade to shut down democracy. They are holding democracy to ransom by refusing to turn up and do their job. Ministers being paid hundreds of thousands of dollars a year and refusing even to turn up into the workplace and do their job, allegedly because of COVID safety. This would have to be the safest COVID workplace in the country. I'm here having been rapid antigen tested, as is every single person in this chamber. I'm here in a chamber that's got additional airflows in order to keep it safe. I'm here in a socially distanced workplace where everybody is double vaxxed, and meanwhile, the government is expecting young workers to be going in, packing supermarket shelves, engaging in essential transport duties without anything like these kinds of protections. And did I mention these ministers are on hundreds of thousands of dollars a year and refusing to turn up and do their job? This isn't about COVID safety. This is about a government running from accountability. They cancel the press conferences, they cancel Parliament, they do everything they can to avoid the hard questions being asked. And I can tell you what this House would be doing if the government allowed it to sit. We'd be passing legislation to protect workers' compensation rights. So if any worker is required to be vaccinated, they're guaranteed to be protected. That's what we'd be doing. We'd be passing legislation to ensure that the upcoming local government election, which the government is just barrelling along to without any COVID safety plan on the 4th of December, would have guaranteed COVID safety protections. We'd be passing legislation to amend the Constitution of New South Wales to allow us to sit virtually in this and any future public health crisis. We're ready to do business. But what also we would be doing is passing orders requiring the government to produce critical documents about the health advice that's been given to them. The health advice that they appeared to maybe comply with, maybe ignore in whole or in part as we went into a very slow lockdown, and the health advice that underpins, if it does, the move out of lockdown. We would be requiring the government to produce further documents about the Premier's involvement in grant after grant and scandal after scandal. We'd be doing our job to hold this government to account, and that's why they don't want to sit here. This isn't about COVID. This is about avoiding accountability. They don't have the numbers in the upper house, so they're using this charade under Standing Order 34 to avoid accountability. Well, I think when you look closely to what that order was for, the requirement of a minister to be in the House, it wasn't designed to shut down or cancel democracy. It was designed to increase the powers of the House. So a minister would be here to have questions directed to them. But it is being abused today, abused by a government that is abusing democracy and thumbing its nose at 8 million people in this state who want accountability in a crisis. A crisis requires more, not less accountability. A crisis requires more, not less work from parliamentarians. A crisis requires a minister on a minister's salary to come and do their job in this place and answer questions. That's what a crisis requires. Now, there are valid arguments about whether or not Standing Order 34 can prevent a sitting of this House. Standing Order 4 of the House says that none of the standing orders should reduce the privileges of the House, the powers of the House. And one of the core privileges of the House is to come together and meet. And I think there is a question for you to decide, Mr. President, about whether or not Standing Order 34 can be abused like this by the government. And maybe it's not today. Maybe it's at a future point. But if they continue to abuse the standing orders to prevent the House from sitting, we need to look carefully at that. And there are multiple occasions before the adoption of Standing Order 34 when, in the absence of a minister, this House continued to sit. Time after time after time, before the adoption of Standing Order 34, where in the absence of a minister, the House continued to sit. Now, it may not be today that we get to that point, Mr. President, but if this deeply arrogant government continues to thumb its nose at democracy, the will of 8 million people in New South Wales who voted for a democracy, not a dictatorship, well, then I can assure you, Mr. President, we'll be back here again, and the privilege question will be brought before you again, Mr. President. This arrogance, this contempt of democracy cannot be allowed to stay.
Mr. President.
The Deputy President.
Thank you. There are only a few brief matters which I wish to bring to your attention. Can I just deal firstly with... Oh,
you finishing?
you sure?
Well,
Look, I don't have a reply, but...
There is no formal order, but if you'd like to yield and do it as a reply, that might probably serve the interests of the House. I'll call the Honourable Emma Hurst.
To the point of order, Mr. President, it's really disappointing that the government has failed to send a minister or parliamentary secretary into Parliament today and to allow a proper sitting of the Legislative Council. We cannot limit the powers of this House. This failure has left the entire democratic process in New South Wales to crumble. In extraordinary circumstances like this, it is all the more important that Parliament continues to sit, and that's why I'm asking you to give serious consideration to reject the Standing Order 34 and the point of order that has been made in this House. Of course, in extraordinary circumstances like this, it's all the more important that we continue to sit. And of course, if the government's real concern is about health precautions, they would have worked with the opposition and the Crossbench to arrange a COVID-safe sitting. This week, my understanding is there was going to be a constitutional amendment which would have allowed Parliament to run virtually. Instead, by the actions today, by failing to send in a minister, they have failed to make any effort towards allowing this democratic institution to operate safely during COVID. In times like this, when the government is making decisions which have huge ramifications for the health and lives of the people of New South Wales, taking us into uncharted territory of the COVID-19 pandemic, it has never been more important to have a functioning parliament, with ministers present so that Parliament can get on with its essential services to the community. And we must continue to sit so the standing order should be rejected. If the government members attended today and if they had bothered to show up, they would have heard about the very many important issues that need to be addressed in Parliament right now. We've got hospitals, particularly in rural and regional areas, that are feeling the strain of COVID and desperately needing additional resources. We've seen a council killing dogs and puppies in pounds using COVID-19 as an excuse. And there's been misinformation spread, including by the New South Wales Police and New South Wales Health, about the ability for essential workers to continue their work. This is why we need Parliament to be up and running. And it's why it is outrageous that they have failed to come in today and allow these processes to take place. We have an obligation to sit, and that's why I'm asking you to reconsider the point of order. Thank you.
President.
Honourable Robert Borsak.
Mr. President, to the point of order. The Shooters, Fishers and Farmers Party support all of the points that are made by the opposition, by the Animal Justice Party, by the Greens and the Honourable Mark Latham. I'm not going to stand here and repeat them all, other than to say that this is a massive abuse of the Standing Order 34. We know that. The fact that the government is prepared to say in advance that they're not going to turn up is a premeditated attempt to stop this Parliament from sitting. We all know that it shouldn't be done that way. If they really were going to turn up and debate and win the debate on the day, they should be here in force talking to us. They have an obligation under democracy to be here, but they're not here. What this indicates to me is that this is a government at the end of its third term really starting to rot, and I mean rot. This is an abuse of power. This is a tyrannical withdrawal of the obligations and powers and privileges of this House. Like Mark Latham, the Honourable Mark Latham, I too believe Standing Order 4 should prevail. But I also am aware of the advice that's been given in relation to what your duties are. But in the end of the day, as long as my arse pokes to the ground, when this House does sit properly, I'll be working to make sure that those privileges are restored and that we don't end up in a situation now where we are begging to come back to this House and exercise our democratic right and represent the people of New South Wales, and this government is giving us the finger. And that is simply not good enough, and they will pay for it at the ballot box. They will pay for it at the ballot box because people do not like what is going on. It's one thing to say that they're acting in the best interests for COVID safety, but it's entirely another thing that this is the only parliament in Australia that is not being allowed to sit at this time. What are they running away from? What are they scared of? Now, I can give this government a guarantee from our party in both houses that the first opportunity we get, we'll be fixing this and fixing it for good, because this is not the way to run a democracy in New South Wales or, in fact, anywhere in Australia.
Join the queue to amend Standing Order 34.
Is any other member, before I go to the Honourable Trevor Khan, seeking the call? The Honourable Reverend Fred Nile.
I just wish to rise in support of the remarks of the Honourable Mark Latham, except for his criticism of one of the members. I believe he outlined all the legal arguments that support this motion, and that the House should be allowed to continue its democratic role and to sit and to debate openly and fairly all the matters that concern the people of this state. And for that reason, I do not support the motion to adjourn the House because we don't have a minister present.
Is anyone else seeking the call? The Honourable Trevor Khan.
Thank you. Mr. President, could I first briefly deal with the issue raised by Mr. David Shoebridge regarding previous examples of not adjourning the House. My understanding is, at least on my reading, and I have to say I'm looking at Evans and Lovelock, or Lovelock and Evans, first edition, is that the instances to which he refers to of the President not having left the chair relate back to, by recollection, two instances in 1917. The instances being on that occasion something along the lines of the President not leaving because it was anticipated that a member who was not a minister was acting on behalf of the minister, and there being some interplay in regards to that. But the clear position has been, at least in the last 50 years, is that it has been an accepted principle. And as for the President looking to the rationale for the application of Standing Order 34, I have to say, what are we asking? That President Bergman and President Primrose, at the time that they vacated the chair, entered into an exercise of weighing up in their mind whether 34 applied because they suspiciously looked at the motivations of the presence or absence of ministers who were not present. What is essentially being asked in that is, with respect, in a sense, a political and intellectual nonsense. The position of Standing Order 34 is clear and explicit in its terms. It doesn't say if the President thinks it's a good idea or if the minister isn't in the bar having a drink. It says if the minister is not present, then the House cannot sit. Now let me deal with the Standing Order 34 point. Standing Order 4 point. Let's first off accept the proposition that Standing Order 4 was introduced at the same time as Standing Order 34. And it was introduced at the same time as, for instance, Standing Order 87, dealing with the rights of a member to speak, or indeed not speak. It came in at the same time as Standing Order 90, dealing with the right, and in other cases, the absence of a right to reply. It came in at the same time as Standing Order 98 came in, which dealt with a motion that a member no longer be heard. It came in at the same time as Standing Order 99, dealing with the closure of debate. And it came in at the same time as Standing Order 91, dealing with the suspension of a member, and Standing Order 94, dealing with the powers of the House not being affected in other circumstances with relation to a member. The standing orders came in as a bundle, and they came in with some generalised expressions, such as Standing Order 4, and then some explicit carve-outs of what could be described as the generalised rights and privileges, some of which I've listed now. It's clear, I'd suggest, that you cannot read down the specific carve-outs like 90, like 98, like 99, 191 and 34 by simply referring to a generalised power. The specific carve-outs must be given proper attention and proper meaning. And what you're being asked to do here with regards to Standing Order 4 is essentially to say, well, it doesn't matter what the House agreed to be their standing orders. It doesn't matter that they introduced Standing Order 34. And indeed, it doesn't matter that past presidents have applied clearly Standing Order 34. We've now got a generalised feel-good Standing Order 4. And look, just do what you like because they say it's what we should do. That's not the way the standing orders were set up. It's not the way the standing orders were set up. Standing orders were set up to set up and regulate the way this parliament ran. Now let me...
Order.
Not to make rules to...
Please don't.
Order. The Deputy President has the call.
Let me just also make this observation. Standing Order 34 falls within Chapter 6 of the Standing Orders, which make repeated references to the presence of the minister in the House, the minister to move the adjournment. the minister to do various other things in that Chapter 6. It creates a whole set of standing orders that deal with the meeting of the House and the responsibilities of ministers in the House. The minister is an integral part, and the presence of the minister is an integral part to the operation of Chapter 6 of the standing orders.
That's why they should
And
be here.
at the very...
Order.
You've been good up until this time.
Order. Please don't respond to interjections
Yeah,
that are
that's fair.
Order. The Deputy President has a...
You must give proper weight to Chapter 6 and you must give proper weight to Standing Order 34. There is no exception created in the rule and you should apply it.
Is there any other member seeking the call? May I first thank all honourable members for their contributions. Certainly has been a very complex matter, and I regret that indeed members who are present and connected via WebEx and ready to contribute remotely have not been able to do so, as I'm sure that their contributions would have been equally as valuable. Members that have been able to contribute today have raised a number of powerful arguments concerning the rights, powers and privileges of this House, pursuant to standing orders like Standing Order 4 or Standing Order 35, or indeed long-standing conventions of the House, notwithstanding the explicit requirement in Standing Order 34 that a minister must be present for the House to sit. These arguments and the counter-arguments put so eloquently by the Deputy President weigh heavily upon my mind. In particular, I note that members found it difficult to reconcile the actions of the government in this matter with the Legislative Council's constitutional role as a House of review. As members are aware, the House is charged with the duty to hold the executive of the day to account as part of our democratic system of responsible government. This was authoritatively expressed by the High Court of Australia in Egan and Willis 1998, where Justices Gaudron, Gummow and Hayne jointly stated, and I quote, "A system of responsible government traditionally has been considered to encompass the means by which Parliament brings the executive to account, so that executive's primary responsibility in its prosecution of government is owed to Parliament." Members also noted that Standing Order 35 explicitly states that the days and times of the House's sitting will be determined by the House, not by the Executive, while Standing Order 36 provides for the recall of the House at the request of an absolute majority of members. Accordingly, members stated that the sittings of the House are a matter for the members of this House, not the Executive Government to determine. I note that as required under Sessional Order 3, in light of the request from the Leader of the House for today's sitting to be postponed, I consulted with the Leader or designated representative of each party and with independent crossbench members. I can report to the House that it was the clear desire of at least 24 out of the 41 members of this House for today's sittings to proceed. Indeed, preparations for this sitting have been made with the active participation of all parties and members of the crossbench over the course of 10 weekly meetings, which also included ministers and the Leader and Deputy Leader of the opposition in the latter stages. Through this process, a comprehensive COVID-safe plan has been developed with the benefit of advice from HIBs, immunologists and occupational hygienists. A copy of this COVID-safe plan was tabled earlier today. As members are aware, this COVID-safe plan goes to great lengths to ensure that the Council can sit with the least possible risk and subject to the most stringent safety measures, including the deployment of rapid antigen tests, the option of members participating virtually via WebEx, and with the expectation that the minimum number of members and staff required to be in attendance will be fully vaccinated. The government has relied on health advice from Dr Kerry Chant, the Chief Health Officer, that the September sittings of Parliament should be deferred on the basis that stay-at-home orders are in place, that staff are required to work from home unless it is not practicable to do so, and any sitting of the Legislative Council would present a significant risk of transmission in Parliament itself and a risk of seeding COVID-19 to unaffected regional communities when MPs and staff return home. As members have pointed out, this advice and the government's position overlooks the fact that normal operations of Parliament are an exempt gathering under Schedule 2 of the Public Health Order concerning public gatherings, and that members of Parliament and parliamentary staff are authorised workers under the terms of the public health orders. This means that the current public health orders contemplate Parliament sitting during this pandemic and enable members and parliamentary staff to travel to Parliament for this purpose. Additionally, as members have articulated today, the COVID Safe Plan appropriately manages the risk of the Council sitting this week, and the option of participation of members via WebEx in their homes eliminates any concerns regional or other members might have in this regard. Nevertheless, the government has today deliberately withheld its ministers from attending the scheduled sitting and, as members have reflected, invoked Standing Order 34 to subvert the will of the House. I note members' advice that they will be bringing forward motions to amend Standing Order 34 to reflect its true purpose so that this tactic cannot be used again in the future by any executive government in New South Wales. The Legislative Council operates in an orderly and deliberative manner and in accordance with long-standing parliamentary law, practice and precedent, and those proposals to amend Standing Order 34 will no doubt be carefully considered in the appropriate manner and at the appropriate time. For today, I am left with Standing Order 34 in the form that I find it. Accordingly, I have no choice but to now leave the chair until the ringing of a long bell. As I do so, I ask that all honourable members take the opportunity to reflect upon their personal responsibility to this House and to the people of New South Wales.